Okay, in this episode of the class, we're going to be talking about the concept of copyright infringement, specifically what a plaintiff has to make out in order to prove a prima facie case of copyright infringement, enabling them to at least theoretically get to a jury. So we'll start by talking a little bit about each one of those elements of a copyright infringement claim, and then we'll continue by looking at how those elements are actually applied in the infringement analysis to particular works of authorship and allegedly infringing copies. So there are two core elements to a copyright infringement action. You'll see these being similar to the elements of infringements and other forms of intellectual property rights. First, the copyright owner has to show that they're actually the owner of a valid copyright. Right? You can't sue on a copyright you don't actually own, and in addition, you can't sue on a copyright that's not valid. Right? So if a copyright, for example, has fallen to the public domain, can't sue it anymore. If you have merely licensed the copyright from someone else, but you aren't actually the owner of the copyright, also you're not the person who's in a position to sue. Or by contrast, if you've transferred, if you were the author, for example, you're the initial copyright owner in whom copyright ownership vested, but you then transferred the work, copyright in the work to someone else, also you would not be the owner, and therefore you would not be the person entitled to sue under the circumstances, although presumably you might very well become a witness or something along those lines in any infringement action. Okay, well, if the plaintiff, if the copyright owner can show owner of a valid copyright, they then have to show how the defendant has gone about infringing upon their work of authorship. And in order to do that, they have to show that there was an unauthorized exercise by the defendant of one of the exclusive rights of a copyright owner. I mean, if we want to kind of run with the property metaphor that is so popular with a lot of people, we could say it's kind of like a trespass to property, right? In other words, you've got certain exclusive rights in the works of authorship that in which you own a copyright. You're the only person as a copyright owner, you're the only person allowed to exercise or permit others to exercise those rights. And if others exercise those rights without your permission, it's as if they're trespassing onto your property. Okay. So in the case of copyright infringement claims, specifically in the case of reproduction claims, which is the primary form of claim we're going to be thinking about right now. We'll think about other claims later. We're thinking primarily about reproduction-based claims now. The copyright owner has to show that the alleged infringer, the defendant, has actually copied the work of authorship that they own. And because of the copying of protected elements, the two works are substantially similar and therefore infringing. There's a lot kind of packed in to those two requirements. I want to highlight, however, though, that all of the exclusive rights of a copyright owner can be the basis for an infringement action, right? So reproduction, adaptation into a derivative work, distribution, the display or performance in public of the work of authorship, all of those can be the basis of an infringement action. Today, we're going to be talking about reproduction, right? The right to create reproductions or derivative works based on the original work of authorship, but distribution, display, and performance are also infringement. It's just the analysis ends up looking a little different because you're not talking about the similarity between the two works, but whether or not the defendant actually engaged in the alleged activities in an infringing way. Okay. So, all the exclusive rights of copyright owners, any of them can be the basis for an infringement action. Okay, so in order to prove copyright infringement, then the two key elements that we're going to be focusing on are actual copying, which is, did the alleged infringer, did the defendant do the kind of thing that could make them a copyright infringer in the first place? And then substantial similarity, did they actually create a work that was sufficiently similar to the plaintiff's work because of the copying of protected elements that their work is actually infringing of the original? Okay, well, there's two key questions we have to ask under the heading of actual copying, or rather, two different ways that a plaintiff can go about proving actual copying, right? One is by direct evidence, right? So if the plaintiff has direct evidence, can show that the defendant actually did in fact admit to, or present evidence that they did actually copy the work in question, then that's fine. That'll satisfy the actual copying requirement. So, like famously, for example, in the recent Blurred Lines case, the Marvin Gaye estate brought an action against Robin Thicke and Pharrell Williams for copying the Marvin Gaye song "Got to Give It Up." And in that case, they were lucky. They were able to prove actual copying quite easily because Robin Thicke and Pharrell Williams did an interview in which they specifically said, yes, we based our song on Marvin Gaye's song, "Got to Give It Up." Well, that's direct evidence of actual copying. They said we copied the song. There's no question at all that that copying took place there. But in most cases, that's not true, right? Alleged infringers typically don't say that they engaged in copying. You have to infer that copying took place from circumstantial evidence. And you can do that either by looking to both access to the work in question and probative similarity between the original work and the allegedly infringing work. So how does that work? You say, well, look, you had access to the work in question. You could have copied from the work because there was the potential for you to have seen it. And because the two works are similar, we can infer that copying took place based on those similarities. Now, why does any of this matter, right? Well, if works are similar, but they're similar not because of copying, but because the defendant arrived at the same or similar looking work on their own, right? That's not copyright infringement, right? If the defendant didn't actually copy from the plaintiff, then they're not an infringer, even if the works are quite similar. It's only the copying without permission that can make the defendant an infringer. Okay, so if we have to infer actual copying from circumstantial evidence, how do we go about doing that? Well, we've got these two factors, access and probative similarity. And essentially what courts do is balance the two against each other. In other words, the more evidence of access, the more you can show that access to the work was available, the less probative similarity you need. And by contrast, the more probative similarity, the more similar the works look, the more plausible it is to infer based on those similarities that copying took place, right? And after all, if the works are very, very similar, it's unlikely, especially if they're more complicated works, that those similarities are a function of chance as opposed to copying, because chance can just seem too unlikely. Well, there's two different methods. I like to kind of characterize them based on analogies made by my friend Greg Dolan as the Kevin Bacon method, right? You show the connections between the plaintiff's work and the alleged infringer in order to show that there was a connection between them, right? And often happens with lesser known works, right? Where you've got a famous defendant and a not so famous plaintiff, where the plaintiff is saying, defendant copied from my work. The defendant says, no, I didn't, I'm famous and you're not. And the plaintiff then says, well, but look, I'm connected to you through this string of people. Therefore, you had access to my work. Therefore, it is plausible to infer that copying took place. The other method is what's known as the Leonard Cohen method, in which everybody knows the work in question. So if a work is really, really famous, then if the defendant's work is similar, we can infer copying based on the fact that everyone's familiar with the plaintiff's work, and therefore the idea that there wasn't access available to the defendant is just implausible, right? Okay, so actual copying, you can either show direct evidence or, as is more commonly the case, rely on circumstantial evidence that enables the fact finder to draw a reasonable inference that actual copying took place. But then, of course, there's also the question of substantial similarity, and that's really the kind of the question of breach, right? It's like, did the kind of copying that the defendant do amount to the kind of copying that constitutes infringement as opposed to permissible copying? And here we have to really draw a distinction between the requirements for showing actual copying and the requirements for showing substantial similarity or improper appropriation of the protected elements of the work in question. And what is that? Well, it was common historically for courts to use the term substantial similarity to apply to both the actual copying analysis and to the ultimate infringement analysis. And that ended up confusing a lot of courts, right? Because the kind of similarities that are relevant to proving or providing circumstantial evidence of actual copying aren't the same elements that are necessarily relevant to showing that infringement took place. After all, works are composed of lots and lots of different elements. Some of those elements are protected by copyright. Some of those elements may not be. Some of those elements may be protected by a copyright that belongs to the plaintiff. Others of those elements may be protected by copyright that doesn't belong to the plaintiffs, and the plaintiffs can only sue on the basis of copyright protected elements in which they actually own the copyright, right? So for example, if a work includes public domain elements, those can't be protected. They can't be the basis of an ultimate infringement action. Likewise, with facts or ideas or elements copied from previously existing works, none of those can be the basis of a plaintiff's copyright infringement action, because the plaintiff either doesn't or can't actually own a copyright in those elements. And yet, copying of those elements could be probative of actual copying. After all, it would be unlikely for the plaintiff's work and the defendant's work to include all of the same uncopyrightable or all of the same elements, potentially copyright elements that don't belong to the plaintiff, right? The similarities allow the drawing of an inference of copying, even if they can't actually support an infringement action, right? So the universe of elements that are relevant to the actual copying analysis is broader than the universe of elements that are relevant to the substantial similarity analysis, because at least in theory, although query how it actually works in practice, at least in theory, only the protected elements that belong to the plaintiff can support an actual infringement analysis. So let's look at this in the context of the two different cases you looked at for the purpose of today's class. So in the Rentmeester v. Nike case, what happened there? A photographer named Jacobus Rentmeester took a photograph of a young Michael Jordan in 1984, while I believe he was still a college basketball player. Court characterized it as a very creative photograph with lots of original elements. Rentmeester posed Michael Jordan from a very low, he was shooting from a very low angle. He used a kind of a fancy lighting setup and encouraged Michael Jordan to take an unusual pose with the basketball flying through the air in a pose kind of based on a dance, classical dance move. Okay, so Nike is at that point planning what became a very, very successful campaign with Michael Jordan over the Air Jordan line of shoes and apparel and so on and so forth, and asked for a copy of this photograph from Rentmeester. In fact, they take out a limited license on the photograph, but Rentmeester is kind of holding the ownership of the photograph pretty close to the chest. Nike goes ahead and hires their own photographer to create a different but similar photograph, which you see on the top right here. And even initially, Rentmeester gets all bent out of shape about this, threatens to sue Nike for copyright infringement, and they basically settle with Rentmeester pay him about $15,000 for a short-term license to the photo, and everything simmers down for a while. Well, fast forward 30 years, and Nike's still using the photo, and more importantly, Nike's using a logo drawn from the photo that they commissioned as the logo for the Air Jordan brand. Okay, so Rentmeester still stewing about this and brings an infringement action against Nike. And if you read the opinion closely, you'll see that in order to avoid the 3-year statute of limitations on copyright infringement actions, Rentmeester is only suing for the 3 years of infringing activity that took place after the point at the point at which he took or filed the infringement action. So this idea in copyright doctrine that ongoing infringement can be the basis of an infringement action, even if the defendant was operating on the assumption that they were not going to be sued for copyright infringement. So as long as the copyright is still in force, there's a constant tolling on the ability to bring an infringement action, even if the plaintiff knows that the alleged infringement has been taking place. Okay, so the question then becomes, is Nike engaging in infringing activity? Well, of course, we've got two different questions that are posed. One is the question of actual copying. The other is the question of substantial similarity. Here, however, there's no question of actual copying. Right? We know quite well that Nike was copying Rentmeester's photo. Right? Nike borrowed Rentmeester's photo and used it as essentially the model for their own photo. And they even previously settled with Rentmeester over a potential infringement action. So it seems pretty clear, actual copying, not an issue in this particular case. The only question is whether or not Nike's photo is sufficiently similar to Rentmeester's photo that it can be infringing. And the question then becomes, how do we go about engaging in that analysis? Well, the district court just dismisses Rentmeester's action outright, saying that there's no possibility for Rentmeester to prove copyright infringement has taken place in this case. And ultimately, 2 judges out of a 3-judge panel vote to affirm. We do have a kind of a partial dissent. We can talk about that briefly. But two judges on the panel affirmed the district court judge on the ground that the Rentmeester photo does not copy sufficient protectable elements that it can be infringing. Now, are the 2 photographs similar? Sure, they're similar, right? But the court says, look, we have to analyze the elements of the photo that were actually copied to see if those copied elements constitute protectable elements. Right? And what does it do? It filters out certain elements, right? It says, well, you can't own an exclusive right over abstract elements of the photo, right? So here, the concept of the pose can't be the basis of copyright infringement. That's too abstract, right? So are the photos similar? Sure, they're similar, but they're similar primarily because they feature Michael Jordan, not a copyrightable element, in a similar abstract pose, not a copyrightable element, right? And it seems like those 2 features are driving the overwhelming bulk of the similarity between the 2 photos. And then the court proceeds to point out the differences between the 2, right? So it says, look, to the extent that there are particular elements, we break down the Rentmeester photo into elements, none of those elements were precisely copied by Nike, and therefore the Nike photograph can't be an infringement of the Rentmeester photograph because the elements that Nike copied are not the protectable elements from the Rentmeester photo, right? To the extent that they are, to the extent that they're similar because of unprotectable elements, and the protected elements of the Rentmeester photo are not the elements that were actually copied by Nike under the circumstances. Now, notably, the court points to 2 different ways of thinking about the infringement analysis, right? So one is the extrinsic test, which is essentially an objective test that says, look at the original photo, right? Identify all of the protectable elements, and then see which, if any, of those protectable elements were copied, and analyze for infringement based on the copying only of protected elements. Okay, fine, objective test. The intrinsic test is a kind of more subjective one that ultimately has to go to the jury, and it kind of asks the jury to say, based on the total look and feel of the two photographs or the two works of authorship, is the accused work an infringing work. Now, we don't get to the intrinsic test here because both the district court and the circuit court say we can dismiss this action on the extrinsic test alone. We don't need to get to the intrinsic total look and feel test. Maybe reflect on, what that says about the nature of the infringement analysis. What's the difference between the two tests? On a total look and feel test, would Rentmeester fare differently than on the extrinsic test that the court actually applied? And then finally, we've got a concurring, more or less partial dissent, partial concurrence that says that actually dismissal was improper because the jury should have been able to engage in the infringement analysis with respect to the two photographs. But even the concurring, dissenting and concurring opinion concludes that the Jumpman logo in question can't be infringing because it copies literally nothing from the Rentmeester photo other than the concept of the pose. But the pose in question is derived only from the Nike photo, not from the original Rentmeester photo, and therefore it can't be infringing. Okay, well, let's look at a somewhat different kind of a work of authorship that kind of hinged on a different analysis, but arguably kind of in tension with the Rentmeester case. Kayberry v. Taylor Gifts. What happens? Kayberry is in the business of making these kinds of tchotchkes, basically, that they sell, that fake rocks with a verse of text inscribed in the fake rock. And one of their competitors, Taylor Gifts, sees that presumably one of the Kayberry products is pretty successful. They want to make a copy of it, and Kayberry sues them for copyright infringement. Well, what's the defense here? Taylor Gifts says, look, this is a rock with words on it. That's all it is. There's no protectable elements to the work of authorship in question. And with no protectable elements, it means there's nothing for us to infringe, right? If the work of authorship isn't and can't be protected by copyright in the first place, we can't be infringers because there's nothing protected about the work for us to infringe. So what happens, right? The district court ultimately finds for the defendant, but the circuit court reverse it. Now, why do they reverse? Essentially, they reverse on the grounds that they think it's at least possible that the work in question, the Kayberry product, could be protected by copyright. Well, wait a minute, how is that? Right? What do we have here? We've got a text that's inscribed on the fake rock. Well, the text is in the public domain, right? And if it's in the public domain, it means it doesn't and can't belong as a copyrightable work of authorship to Kayberry. So no copyright protection in the text itself. What about the font? Well, it's just a font that Kayberry used from someone else, right? They don't own that, right? The structure of how the poem is broken up, it doesn't really seem like a copyrightable element either. What about the rock? Well, the rock is a fake rock, right? I mean, is that a protectable element? Certainly the concept of a fake rock isn't a protectable element. So what is there that could possibly be protected? The court says, look, you can't just look at each one of those elements in isolation. To ask whether or not the work of authorship in question can potentially be copyright protectable, you have to look at all of the elements put together. And even if each of the individual elements isn't protectable, it's at least possible that the combination of all of those individual elements could be copyrightable. So think back to Facie v. Rural, right? What happened there? Court says, look, the individual telephone listings can't be protectable. They're just facts about the world, for better or for worse, right? But a compilation of facts about the world is potentially copyrightable if it has an original element, if it has an original selection, ordering, or arrangement, right? So even though the individual elements of the work in question could not at all be protected by copyright, the combination of unprotectable elements could be protected if that combination was qua combination original sufficient to qualify for copyright protection. That's the same thing that's happening here, right? The court is breaking down the work in question into a whole group of different elements, saying each individual element is not protectable by copyright, but if you take all those individual elements and combine them together, it is at least possible that that combination could satisfy the originality requirement and therefore be a protectable element in the aggregate. And if that protectable element in the aggregate is what was copied by the defendant, then it's possible that the defendant is an infringer.